So where does employer liability set with respect to sexual harassment? When if the supervisor has a responsibility towards the employees, particularly when a tangible employment action is taken. Basically, we see this with quid pro quo harassment, right? The employers are liable for the tangible acts of the supervisors, and so when a supervisor makes a decision to engage in quid pro quo, it is the employer that's liable for that, for allowing it to occur. So when there's a presence of a paper trail regarding the job actions, the assumption is, of course, that the employer should know about this, and that hopefully helps the employer to identify when the quid pro quo is occurring, particularly if there are complaints filed. Then it's the employer's responsibility to immediately act on that, because they are then liable if it's not addressed properly with the employee. So what do we do when there is no tangible employment action that occurs between the supervisor and the employee? Technically, the employer is not strictly liable. Obviously, there are some boundary conditions to deal with. But in terms of Ellerth and Farragher, the defense is that the employer had a reasonable sexual harassment policy to prevent and address harassment, but the harassed employee unreasonably failed to use it. They didn't report the harassment. If you don't report the harassment, the employer is not going to be liable for it. Then it's one-on-one with the employee. That's a separate issue. But if you didn't report it, you have to report it. If you didn't report it, you run into problems where the employer is not going to take on the liability for something that they're not aware of. Right? So if there is a tangible path, right, a tangible pattern of things, we can see that you didn't get promoted, or that you didn't get a job opportunity, or you got demoted for some particular reason. We can see that, and then we're liable for that. But a non-tangible one that isn't involving a particular hiring decision, then it really is on you as the victim or the harassee to make sure that you can, you put your case forward, and you ultimately um, have to complain for it to be taken seriously, and to be able to hold the organization liable if they don't address it. In terms of liability for coworker harassment or third-party harassment, the harasser and the harassee are on the same level. The harasser is not employed by the employer, or there is a client situation involved. The employer is liable for the acts of the harassment if they were known, but no corrective action was taken. And so even if harassment happens between coworkers and someone is being sexual or inappropriate in the workplace, if the employer knows about the behavior and chooses not to act, they're still liable for that. And as you can see in scenario one, the response, obviously, by the city of Boca Raton, right? Don't look at it, is not going to be adequate enough. I mean, if it's there, it's hard to not see it, right? The employer does have a duty to not only address the issue, but to respond in an effective manner that illustrates that they're taking it seriously and that they're making an action to fix it. How do we determine whether or not someone's allegations are true? And as I said before, it is our responsibility in HR to make sure that we're continually engaging in investigations appropriately. We're not making assumptions of guilt or innocence up front. We're investigating immediately and taking those charges and those claims very seriously. There has to be inherent plausibility in this scenario. We have to check the demeanor of the individuals involved. We need to make sure that we have who's got the motive to falsify. Is there a motive to falsify? Because sometimes victims can do that, or alleged victims will do that, where they will falsify information because they're trying to get back at somebody for something. If there's corroboration or witnesses, that's appropriate. And if there is a past record of the individual who is engaging in the behaviors, then that is also plays in the the plaintiff's favor. We don't get others involved except on a need-to-know basis. So we don't get them involved except when we see corroboration when we know that somebody was a witness, somebody saw it. And the whole third party witness thing, how do we get people engaged in the process and reporting it when they see it? This is getting bystanders to stand up for anything. Even something that's criminal is always hard, but imagine the nuances in a workplace environment where your job is at risk, your livelihood's at risk. People are less likely to want to speak up and say something. So how do we deal with retaliation and employee privacy? So when a plaintiff makes a complaint about sexual harassment, the harasser has to be told about the complaint in order for it to be addressed. You cannot make a complaint without letting the person know. Or certainly you can't make a complaint and expect the organization to address it if the harasser is not told, right, what's going on and why. So it is important that we make sure that if you're going to make a complaint, recognize if you want something to change, you have to make sure that the harasser is made aware of it. And things can happen, and that's what happened for me, right? When I first made my complaint, I said, no, I don't want anything done right now. I'm simply reporting it to you so that you are aware, and I'm going to try to see if this is a continued problem and if I can address it myself. And when it didn't change, then I went back to them and said, I'm ready to make a complaint. I'm ready to make this public. And then the complaint went to him, and then things escalated from there. So the retaliation against harassees and witnesses is illegal. And my harasser did that. He actually harassed me. I had a retaliation claim against him, and I was able to make my case for retaliation, as well. We're seeing a dramatic rise in retaliation claims. People are not putting up and not tolerating it when they make a legitimate complaint and it's not taken seriously, and then the organization allows the person to retaliate against them, or the organization itself retaliates against the harassee or the victim in that circumstance. So what do we mean by corrective action? Employers must take immediate and appropriate corrective action. Number one, stop the harassment. All right, just stop it. Tell them this is not okay, that this has to stop right now. Not be out of proportion to the act. Like a zero tolerance policy is very difficult to use when it is, for example, like a hostile working environment. That's not always an appropriate response, where somebody gets fired immediately given zero tolerance. So it needs to be in proportion. So if somebody has to be discharge worthy for that to happen. Now, I mean, a sexual proposition and finding evidence that is in fact true, then yes, once you've investigated it and you recognize that that it actually did happen, you've got all the evidence in front of you, then discharge is fine. But we don't want to be in a situation where even the perception that someone was harassed, or the perception or the allegation that someone was harassed, results in someone being fired. And this was a big case with Miller Brewing Company, where one of the employees had engaged in retelling an episode of the Seinfeld. And in that episode of Seinfeld, he was talking about being the master of his domain, which was a story about masturbation. And it was between two colleagues talking amongst themselves. The individual walked by them, never asked them to stop, and went and reported them to HR, and immediately they were fired. For the person telling the story was fired without giving him due process to talk about it or giving him an opportunity to stop the behaviors, right? So there was no understanding, right, of the nuances of the conversation, and maybe they shouldn't have been talking about it at work, but you give somebody an opportunity to make a change in their behaviors. That's the goal. We want to make sure our remedies don't have the effect of punishing the harassee by transferring them out the door or to a different place, or anything along that nature. That's just not appropriate for them to lose. The person who is complaining shouldn't have to move from their job because the person above them is not appropriate. In terms of damages in jury trials, the Civil Rights Act of 1991, which was an amendment to the Act of 1964, said that employees suing for sexual harassment can ask for a jury trial, which was not allowed in the past. So that really opens up the doors for a jury of your peers reviewing your case. And then also, you can ask for up to 300,000 in compensatory or punitive damages and unlimited medical damages for harassment claims. Some states, the harasser can be personally liable for damages, but that's on a state-by-state basis. The EEOC has institutionalized alternative dispute resolution to sort of deal with some of these things so they don't necessarily go to trial. Harassment can be a basis for other civil or tort liability or criminal liability arising out of the same actions. For example, in Meritor Savings versus Vincent, which was the case that I was thinking about before when I blanked out on it, if there's assault or battery or emotional distress or false imprisonment, someone's locked in a room or locked in an office and they can't escape, interference with any kind of contractual relations, these are not only possible for civil but also criminal. Like you can have criminal battery, criminal assault, things like that. So the action could form the basis for criminal prosecution, particularly if non-consensual sex or / rape occurs. So we end with some lovely management tips. Number one, you have to have a very clear anti-sexual harassment policy in your organization. That's step one. There are many more steps that come after that. A lot of organizations sort of begin and end with the sexual harassment policy, and that's not enough. There's much more that we need to be doing. We need to take a top-down approach to deter sexual harassment because we know that sexual harassment culture comes from the top. So if the CEO and top management team are engaging in these behaviors, it gives permission for everybody in the organization to behave that way. So we need to first hold our top management team accountable, and then the tone that they lead from at the top will perpetuate throughout the organization. We want to create and disseminate information about effective reporting mechanisms for harassing situations. And so we want to make sure that there is a system in place to collect the information. We want to consistently remind employees about our policy, that there's constant messaging as part of the culture that they know that harassment is not okay. We want to provide employees with training or information that helps them to recognize sexual harassment and to identify it, and then to be empowered to report it when they see it. We want to make sure that reported incidents are taken seriously. Next, we need to make sure that when we are training employees, that they're getting effective, interactive, and engaging training, that it's not one-dimensional, boring, sitting in the classroom sort of stuff, that it gives them scenarios and role plays and activities to practice skills, not only to practice skills saying no and reporting information, but also for third-party observers to go to their boss and feel empowered to be able to say, there's a harassment situation going on and we need to address it. We want to create an environment where sexual harassment is not tolerated, and that is the culture that has to come from the top. The tone from the top is the way that is going to lead any organization out of a culture of sexual harassment and into one that is more inclusive and non-discriminatory. And we've said this for all these other, different types of discrimination that we've talked about already, and it's the same thing, and if not more so important for issues of sexual harassment. It has to start at the top. We also want to keep an eye out for, we want to make sure that we are properly investigating all the sexual harassment claims. We want to ensure that any time a complaint is made, that it's taken seriously and that it's appropriately and quickly investigated. Not quickly investigated such that we're short shrifting the investigation process, but that we're promptly getting to it and we're working through it in an efficient manner. We want to keep an eye out for any anti-female animus, because that can also create a hostile working environment and can result in a sexual harassment claim. We want to make sure that there's corrective action that is commensurate with the policy violation. Not all circumstances deserve a zero tolerance policy and to be fired. So we need to figure out what our progressive discipline policy is going to look like and implement that consistently. We want to make sure also that we're keeping that workplace friendly, open, and respectful consistently. Thank you.